The information found in this video and related presentation is provided by the Retirement Research Foundation and is for educational and informational purposes only. Nothing in this video should be considered to be tax or investment advice. Welcome. Thanks for joining me here at the Retirement Research Foundation. I'm Daniel Rondberg, and with me is Ben Skinner from Taylor Skinner Law. Ben, so glad to have you here today. Let's break this down. What is probate? Why do people want to avoid it so bad? What's so bad about it?
That's a great question.
First of all, and then second of all, what's the difference between having a will through probate and a trust, to avoid that process?
Yeah, good question. So probate is just a court-supervised administration of your estate. And I always tell people if you have the government involved in something, it usually makes it slower and more expensive. And that's exactly what happens when you have a court supervising an administration. Also, often there are disputes over wills, and that ends up being in a formal probate proceeding. Those can be very lengthy and very costly. So that can be avoided with a little bit of planning. It can be avoided even with a will. That's the common misconception. If you have a will, you need to have some other documents along with that, like a beneficiary deed on your house. That is a document that doesn't transfer title. It sits in the chain of title, and it just says what happens to your house when you pass away. No different than the beneficiary designation on your IRA or your 401k.
Okay.
So that way, that under that model, you can avoid the probate. Probate does get a bad rap, and a lot of attorneys and people have used it as a scare tactic over the years to sell more expensive estate planning plans.
Okay.
In Arizona, the average cost for an informal probate, I would say, is between $4,000 to $5,000, and it's 6 months in length.
Okay.
It can be much longer, and it can be a lot more money depending on which law firm you go to, and where in the valley that firm's located, or where in the state it's located. So it's definitely something that can be avoided and should be avoided, especially with just a little bit of planning. It can be avoided.
Okay, so that's the kind of the fear is that it's a lengthy process. Yeah. It's going to be the government deciding, what's going to go where for you.
Well, it's decided by your estate planning documents, but you just have the court's hand kind of in all of it.
Yeah. Because I always tell people, if you don't have a plan for long-term care, you don't have an estate plan. You really do have a plan. It's just the government's plan for you.
It's a one size fits all plan.
So there is always a plan, and the probate court will pick that up and then administer your affairs and your estate. So to avoid probate, you're saying that you can use a will and beneficiary designations on your assets. And that's some new information because not a lot of people know you could put a beneficiary designation on your house.
Yeah, that's a relatively new type of deed in Arizona. It's within the last 10 years.
But what's that deed called?
It's a beneficiary deed.
Beneficiary deed. Okay, I've heard warranty deed. I've heard
warranty deed is just a straight deed that just transfers title. But this one would just sit in your chain of title. It would be recorded after your most recent deed, and it would just say who gets your house when you pass away. That could be family. It could be a charity. It could be whatever you want.
Okay.
But that keeps it from. So here's what triggers a probate in Arizona. This is going to vary from state to state. But in Arizona, if you have greater than $75,000 of personal property or greater than $100,000 of equity in real estate, you're going to be required to have a probate. Now that can be gotten around with this beneficiary designation on a house, or the other way that's very common to get around that is to have a trust. A trust is kind of like a corporation or an LLC where it's an entity, it's a business entity that is recognized as a separate and distinct entity from you as you're planning your estate. So the idea is when you pass away, that entity still lives on and it owns all of your property. It owns your real estate, it owns your personal property, and therefore there's no government or court involvement in that administration of the trust estate. So you're asking how long, what's a probate like with a trust? Well, there shouldn't be a probate if you have a trust.
Gotcha. That's the goal. Yeah. So obviously people need to fund their trust once it's created.
That's the key.
So if you don't carry out the steps afterward to get the documents correctly, you got to put your house in there, you got to put your assets in there. That brings up some interesting points. A couple things I want to touch on. You talked about so people need trust to avoid probate, essentially.
A trust is one tool to avoid
probate. Tool to avoid probate, or you could do beneficiary designations with the will. Now, correct me if I'm wrong, are wills public record and trusts are not, or how does that work? Are those...
That's a great question, too. People often think these documents are filed in some public repository. They're not. The only place they're kept is in the person's individual files, and usually the attorney keeps a copy.
With a trust?
With both.
With both. So wills are not going to go through a public...
They only become public if they're probated. So if they're probated, then they become a part of the court's record, and then they're accessible to anybody that wants to take the time to go down to the courthouse.